Legal Developments, Deep Dive, February 11, 2026. To provide an overview, the following table summarizes each topic, including the jurisdiction, key legal issue, the court or authority involved, and potential implications. Topic: Jurisdiction. Key legal issue. Court/body involved. Potential implications. Execution of Ronald P. Heath, stay denied, execution carried out. Florida, state case, and U.S. Death penalty appeal, stay of execution, Eighth Amendment and procedural claims, unanimous jury, clemency, etc. Florida Supreme Court, U.S. Supreme Court affirms continued enforcement of capital punishment. SCOTUS's denial signals high bar for last-minute stays. Precedent holds no unanimity required for death sentence. Could embolden states like Florida pursuing rapid executions, raising debate on due process and execution protocols. Pending SCOTUS case, parental notification, transgender student policy. California and U.S. federal. Parent rights versus student privacy when a minor adopts a new name/pronouns at school. First Amendment, religious exercise, and 14th Amendment, parental due process, versus equal protection and privacy for LGBTQ students. U.S. Supreme Court, interim docket, 9th Circle State District Court injunction. A pivotal church and state and parental rights case. A ruling for parents could require schools nationwide to inform parents or allow opt-outs on gender/pronoun issues, potentially undermining student confidentiality policies, Politico.com. A ruling for the state would uphold protections for transgender youth in schools, reinforcing student privacy and anti-discrimination measures. Ninth Circuit on TPS termination, Honduras, Nepal, Nicaragua. United States, immigration. Executive authority on immigration versus APA limits. Lawfulness of abruptly ending temporary protected status for long-resident migrants, including claims of APA violation and discrimination. U.S. Court of Appeals, 9th Circuit, 3-judge panel stay, lower court, ND-Cal, had enjoined termination. By allowing TPS termination to proceed, the court signals deference to executive immigration policy, Yahoo.com. 60,000 plus migrants face loss of legal status, risking deportation, law.ucla.edu. Citing Supreme Court shadow docket precedents, e.g. on TPS for Venezuelans, Yahoo.com, the decision highlights how interim Supreme Court orders guide lower courts. Puts pressure on Congress to address long-term TPS holders' status and underscores the impact of the Supreme Court's emergency rulings on immigration policy. Kerala High Court, a corporal punishment case. India, Kerala. Legality of mild corporal punishment in schools. Interpretation of Bharatiya Nyaya Sanhita Section 118(1), Dangerous Weapons, and Juvenile Justice Act Section 75, Cruelty to Children, in context of a teacher caning a student. High Court of Kerala, single judge. Clarifies that reasonable corporal discipline by teachers in loco parentis can be lawful, onmanorma.com. A cane is not a dangerous weapon per se, onmanorma.com, and discipline without malice or injury isn't criminal. This ruling may influence school discipline policies in India. It reassures teachers of some discretion but also reinforces limits, no excessive force or malicious intent. It has spurred discussion on child rights versus traditional disciplinary practices, likely prompting calls for clearer guidelines and teacher training to prevent abuse. Elk Grove traffic collision, February 11, 2026. California, state law. Liability and legal fallout of a highway accident. Potential negligence, insurance claims, and any criminal liability, if DUI or gross negligence involved. California Highway Patrol, investigation, civil courts if lawsuits filed. Civil liability will hinge on fault, an at-fault driver can be liable for injuries and damages. California uses comparative negligence. Injured victims may file personal injury suits for compensation. Insurance claims are expected. Disputes over fault or coverage could lead to litigation or settlement negotiations. If serious wrongdoing, e.g. DUI, reckless driving, caused the crash, criminal charges, like DUI or vehicular manslaughter, could ensue. The incident underscores the legal process after accidents, police reports as evidence, cashlegal.com, insurance duties, and the potential need for civil suits if insurance is inadequate or contested. Justice Ketanji Brown Jackson's comments on deliberation, tariff case. United States, U.S. Supreme Court. Judicial transparency and timing, explaining why complex decisions, e.g., on tariff policy, take time. Balancing thorough deliberation versus public pressure for quick decisions. U.S. Supreme Court, Justice's public remarks in media. Jackson's statement highlights the court's commitment to careful, methodical decision-making, Yahoo.com. It has two implications. 1. Public expectations. It educates the public that nuanced cases, such as those involving tariffs and trade law, may require extensive analysis, thus managing expectations for delayed rulings. 2. Judicial transparency. By openly discussing the court's internal process, thoroughly consider issues, striving for clear determinations, she adds a measure of transparency and trust in the court's work. Her comments implicitly contrast the slow, reasoned merits process with the faster shadow docket, assuring that important decisions aren't rushed. This could bolster public confidence that even politically sensitive cases, like tariffs affecting national policy, will be decided on legal merits rather than haste. Justice Alito on Scalia's legacy, wrote to Dobbs. United States, U.S. Supreme Court. Jurisprudential influence over time, Scalia's originalist philosophy and its role in overturning Roe v. Wade. Reflections on the continuity from Scalia's era to the current court's decisions, e.g. Dobbs. Perspective of a U.S. Supreme Court Justice, Alito interview in Politico. Demonstrates how a justice's long-term influence can shape landmark outcomes. Scalia's persistent critiques of Roe, often in dissent, laid the groundwork that the Dobbs majority, authored by Alito, would later use to reverse that precedent, Yahoo.com. Alito's view that Scalia started so much and would approve of Dobbs underscores the through line from originalist legal theories to contemporary rulings. He also notes Scalia would be appalled by today's polarized climate, Politico.com, reflecting concern about the court's perception and the politicization of judicial debates. These insights suggest the current conservative majority sees itself as fulfilling Scalia's constitutional vision, while also navigating a more contentious social environment. Below is a detailed analysis of each development. 1. U.S. Supreme Court denial of stay in Ronald Palmer Heath execution, Florida. What happened? The U.S. Supreme Court denied a last-minute stay of execution for Florida death row inmate Ronald Palmer Heath, who was convicted of a 1989 murder, thereby allowing Florida to carry out his execution on February 10, 2026. Hours after the denial, Heath was executed by lethal injection, becoming the second person executed in the United States in 2026 and the first in Florida that year. The per curiam denial came without a published opinion, indicating that a majority of the justices saw no sufficient grounds to halt the execution at the 11th hour. This outcome followed the Florida Supreme Court's refusal a week earlier to grant relief, as that court dismissed Heath's final appeals and also refused to stay the execution. Yahoo.com. Heath's legal claims. In his final appeals, Heath's attorneys raised multiple arguments challenging the lawfulness of the execution. They contended that Florida failed to follow its own execution protocols and that the state's rushed schedule of executions risked procedural errors and Eighth Amendment violations, noting Florida's unusually high pace of 19 executions in 2025. Heath also argued that Florida's clemency process was applied unfairly, denying him due process, and that his brain development had been stunted by incarceration as a youth, potentially mitigating his culpability. One focal claim was that his death sentence was constitutionally flawed because the jury's recommendation for death was not unanimous. The vote was 10-2. Florida is among the few states that have allowed non-unanimous jury recommendations in capital cases. Heath's counsel pointed to the lack of jury unanimity as contrary to evolving standards of decency and in tension with a line of cases requiring heightened reliability in death penalty verdicts. Yahoo.com, Flcourtsm, courts.gov. Why the courts rejected the stay. Both the Florida Supreme Court and the U.S. Supreme Court found Heath's arguments insufficient. The Florida Supreme Court ruled on February 3, 2026 that all of Heath's claims either were procedurally barred or failed on the merits. Notably, regarding the non-unanimous jury issue, the Florida court cited its recent decision in Dilbeck v. State, 2023, reaffirming that the Supreme Court's precedent establishes that the Eighth Amendment does not require a unanimous jury recommendation of death. In other words, despite the U.S. Supreme Court's 2016 ruling in Hurst v. Florida, which struck down Florida's old capital sentencing scheme for giving judges too much power, neither the U.S. nor Florida Supreme Courts interpret the Eighth Amendment as mandating a 12-0 jury vote for death sentences going forward. Florida's legislature had amended the law post-Hurst to require unanimity at the time, but later, in 2023, relaxed the requirement to 8-4. However, Heath's sentence became final decades ago, in 1995, and courts have held that newer sentencing standards do not retroactively reopen such old cases. The Florida Supreme Court also rejected Heath's challenge to the state's execution protocol and clemency process, finding no evidence that any deviations rose to the level of an unconstitutional, cruel and unusual punishment or a due process violation. The court noted that Heath had litigated and lost multiple post-conviction claims over the years, exhausting his legal remedies. After this unequivocal decision by Florida's highest court, Heath petitioned the U.S. Supreme Court, but the justices declined relief, with no dissents noted. Flcourtsm, courts.gov, Flcourtsm, courts.gov, Flcourtsm, courts.gov. Legal precedent and implications. The U.S. Supreme Court's refusal to stay Heath's execution is consistent with its recent pattern of reluctance to intervene in state capital punishment cases absent clear proof of a constitutional violation, for example, a substantial claim of actual innocence or incompetence. Here, Heath's claims, involving procedural issues and non-unanimous jury sentencing, did not convince the court to deviate from precedent upholding Florida's processes. In Jones v. Mississippi, 2021, the Supreme Court emphasized the primacy of state discretion in sentencing minors to life without parole. By analogy, the court's action in Heath suggests deference to state criminal judgments when all appeals have run their course. Furthermore, the handling of the jury unanimity issue reflects the court's stance that a jury's advisory recommendation is not constitutionally required to be unanimous so long as the jury, unanimously, found the defendant eligible for the death penalty, a principle that Florida's courts, citing U.S. Supreme Court jurisprudence, have embraced. The outcome reinforces that the current Supreme Court will not act as a court of last resort to routinely second-guess state death sentences. This sends a signal that states like Florida, which recently increased the pace of executions and even lowered the jury vote threshold for new death sentences, have a green light unless a clear constitutional line is crossed. Florida's governor had signed a record number of death warrants in the prior year, nearly 4 times more executions in 2025 than any other state, part of a broader national trend of some states accelerating executions. The failure of Heath's appeals, despite arguments about rushed procedures and non-unanimous juries, may embolden such states to continue aggressive use of capital punishment. On the other hand, the case highlights ongoing debates about execution protocols and fairness. Dissenting voices, including the Florida Conference of Catholic Bishops, which urged clemency for Heath, argue that the push to expedite executions can lead to casual indifference to potential constitutional errors. In sum, the Heath case exemplifies the judiciary's current approach, a strong reluctance to interfere with state-imposed death sentences in the final stages, even as questions of procedural justice and evolving standards persist in public discourse. Yahoo.com. 2. California's transgender student parental notification policy, pending Supreme Court case. Background: a contentious California state law, enacted in 2024, prohibits public school officials from informing parents if a student asks to use a different name or pronouns at school, or otherwise discloses a gender identity or sexual orientation different from what's in school records. The law was a response to several local school districts adopting forced outing policies that would have required notifying parents of such student choices. California's legislature, backed by Governor Gavin Newsom, barred this practice statewide, citing the need to protect transgender and LGBTQ+ youth from potential harm if they are involuntarily outed at home. The law contains an exception permitting disclosure in compelling circumstances, e.g. imminent safety issues, but critics argue that exception is too vague. Politico.com. The legal challenge: in late 2025, a group of parents, represented by the Thomas More Society, a conservative Catholic legal organization, sued to block California's law on the grounds that it violates their constitutional rights. They argue that preventing parents from knowing about such a fundamental aspect of their child's life infringes on parental rights and their freedom to raise their children in line with their religious beliefs. Essentially, they contend that parents have a right, grounded in the 14th Amendment, which protects the care, custody, and control of one's children, to be informed of and involved in decisions about a child's gender identity. Moreover, they frame it as a First Amendment issue. Many of the challenger parents have religious objections to the concept of gender transition, and they claim the law forces them to remain unaware and thus unable to guide their child according to their faith, a burden on their free exercise of religion. Politico.com, Politico.com, Politico.com. In December 2025, U.S. District Judge Roger Benitez, in San Diego, agreed with the challengers in part. Judge Benitez issued a preliminary injunction on December 22, 2025, preventing enforcement of the key provisions of the law for the plaintiffs. He held that parents have a right to receive gender identity information and teachers have a right to provide accurate information about a child's gender identity, finding that the California law likely violated parents' constitutional rights. Notably, Judge Benitez carved out an exemption allowing parents with religious objections to opt their children out of the law's non-disclosure requirement, effectively permitting those parents to be notified if their child is using a different name or pronoun at school. Politico.com. Current status. At the Supreme Court, the Ninth Circuit Court of Appeals swiftly intervened at California's request. A three-judge panel of the Ninth Circuit temporarily stayed Judge Benitez's injunction, first pausing it, and then on appeal putting it on hold until the court can fully hear the case. This means the California law remains in effect statewide for now. Schools are still barred from parental notification in most circumstances. The challengers have treated the Ninth Circuit stay as an emergency situation and have now petitioned the U.S. Supreme Court to lift the stay and reinstate Judge Benitez's ruling. In early January 2026, they filed an emergency application to the Supreme Court, arguing that the Ninth Circuit's action was an extreme infringement on parents' rights. Politico.com. The case has landed on the Supreme Court's shadow docket, meaning the court can decide whether to grant or deny immediate relief without full briefing or oral argument. As of February 11, 2026, no decision had yet been announced, but the court could rule at any time. The next date the justices were scheduled to issue orders or opinions was February 20, 2026, leading to speculation that a ruling on this matter might come by then if not sooner. Yahoo.com. Legal arguments and context. This case sits at the intersection of parental rights, religious freedom, and LGBTQ student rights. The parents challenging the law lean heavily on a recent Supreme Court precedent, Mahmoud v. Taylor, decided June 27, 2025. In Mahmoud, the Supreme Court in a 6-3 decision sided with parents who wanted to opt their children out of a public school's LGBTQ inclusive curriculum on religious grounds. The conservative majority in that case, opinion by Justice Alito, held that exposure to ideas violating the parents' religious beliefs, without an option to opt out, can constitute a burden on free exercise, and it required the school to accommodate those parents. The Thomas More Society is invoking Mahmoud as a direct parallel. If parents have a right to opt out of certain lessons that conflict with their faith, they argue, parents should also have a right to opt in to knowledge about their own child's asserted gender identity, especially when their faith teaches them that gender transitions are harmful or immoral. They contend that not informing parents effectively forces the child to live a life at school that the parents are kept ignorant of, undermining the parents' ability to instruct and care for their child consistent with their beliefs. Politico.com, en.wikipedia.org, en.wikipedia.org, Politico.com, Politico.com. On the other side, California, led by Attorney General Rob Bonta, defends the law as a necessary protection for students. The state emphasizes the privacy and safety rights of transgender and gender nonconforming youth, arguing that mandatory disclosure to parents could lead to bullying at home, loss of support, or even abuse for some students. California asserts that the law does not infringe parents' general rights to direct their children's upbringing. Parents remain free to discuss gender identity with their children, but the school's duty of confidentiality in this narrow area serves a compelling interest in protecting minor students. The state also notes that the law still permits disclosure if there is a compelling need, such as a threat of self-harm. Essentially, California's argument is that teachers and schools' obligation to keep a student's gender status confidential, absent consent, is part of creating a safe educational environment, and that the Constitution does not guarantee parents access to every detail of a child's school life, especially where disclosure might endanger the child. They liken it to confidentiality that schools maintain for student counseling sessions or sensitive health information, which has been recognized in some contexts. Politico.com, Politico.com. This battle also raises a free speech issue in a tangential way. The California law prohibits teachers from outing students, effectively compelling teachers to withhold information. Some teachers, and the parents they support, argue this gags them from speaking truthfully to parents. However, since teachers are public employees, their speech in the course of their duties is generally considered government speech that can be regulated by their employer. Thus, the stronger claims legally are the parents' rights claims rather than the teacher's speech rights. Potential outcomes: the Supreme Court's decision on the emergency application will either let the law remain in force during litigation or block it. If the court denies the emergency relief, California's law will stay effective at least until the Ninth Circuit, and possibly the Supreme Court later, rules on the merits. That would be seen as the court not finding an urgent, irreparable harm and leaving the law in place for now, perhaps signaling that a majority is not convinced the challengers have a likely win. Alternatively, the Supreme Court could grant relief and reinstate the district court's injunction. That would immediately allow schools to notify parents, at least those who opt out on religious grounds, while the case proceeds, and it might foreshadow the court's willingness to ultimately strike down the law. Such a move would be celebrated by parental rights advocates but seen as a setback for LGBTQ protections. In the long term, if this case reaches the Supreme Court on the merits, it could become a landmark decision delineating the scope of parental rights in public education. Until recently, courts often held that public schools could introduce curricula and policies without providing opt-outs for parents, except in narrow situations. But the court's trajectory in Mahmoud and related cases suggests a jurisprudence increasingly sympathetic to parental religious and speech rights. A broad ruling against California could require school districts nationwide to accommodate parents who object to LGBT-related policies, potentially clashing with anti-discrimination principles. Conversely, if California prevails, it would affirm states' ability to implement measures aimed at protecting vulnerable student populations even when parents object, confirming some limit to parental control in the school setting. Either way, the case highlights a deepening national debate. Where is the line between a parent's right to know and direct their child's upbringing, and a student's right to privacy and self-expression in matters of gender and sexuality? The Supreme Court's handling of this issue, even at the interim stage, will be closely watched. In the words of one legal commentator, the court is effectively deciding whether policies seen by some as gender secrecy are an unconstitutional intrusion on parental authority or a necessary shield for students in an era of intense culture wars. 3. Ninth Circuit upholds ending temporary protected status, TPS, for migrants from Nepal, Honduras, and Nicaragua. The ruling, on February 9, 2026, a three-judge panel of the U.S. Court of Appeals for the Ninth Circuit cleared the way for the termination of temporary protected status, TPS, for over 60,000 longtime U.S. residents from Honduras, Nepal, and Nicaragua. The panel granted an emergency stay of a lower court's decision that had previously blocked the federal government from ending TPS for those countries. In practical terms, the Ninth Circuit stay allows the Department of Homeland Security to proceed with canceling TPS designations for those nations, at least pending the outcome of the ongoing appeal. TPS termination means that nationals of these countries who have lived and worked in the U.S. legally, in many cases for decades, under the TPS program could lose their protection from deportation and their work authorization as soon as the stay took effect. Yahoo.com, gmla.com. Background on TPS. Temporary Protected Status is a humanitarian program created by federal law, the Immigration Act of 1990, that grants temporary relief from deportation and work permits to foreign nationals already in the U.S. when their home countries experience armed conflict, natural disasters, or other extraordinary conditions. TPS is typically designated by the Department of Homeland Security, DHS, for 6 to 18 months and can be extended repeatedly. Beneficiaries often live in the U.S. for many years under successive extensions. In this case, Honduras and Nicaragua were first given TPS in 1999, after Hurricane Mitch, and Nepal in 2015, after a major earthquake. Many holders have U.S. citizen children and deep roots in American communities. In 2018, the Trump administration announced plans to terminate TPS for several countries, arguing the original conditions had improved. This prompted lawsuits. A group of TPS holders and their families sued, in a case known as Ramos versus Nielsen, to stop the termination of TPS for El Salvador, Nicaragua, Sudan, and Haiti, claiming the decision was arbitrary and motivated by discrimination. A federal judge in California issued a nationwide injunction in 2018 blocking those terminations. That case was on appeal when the presidential administration changed in 2021. The Biden administration then kept TPS in place for those countries, effectively mooting part of the dispute. However, TPS for Honduras and Nepal, and later Nicaragua, were addressed in a related case filed in 2019, Otterai v. Nielsen, which had been on hold during settlement talks. Fast forward to 2025, with the new, second, Trump administration in office, DHS under Secretary Kristi Noem renewed efforts to end TPS for certain countries, including Honduras, Nepal, and Nicaragua, many of the same beneficiaries as in the prior cases. This prompted a fresh lawsuit, National TPS Alliance vs. Noem, sometimes called NTPSA2, on behalf of TPS holders from those nations. law.ucla.edu. Lower court's findings. On December 31, 2025, a federal district court, Northern District of California, ruled in favor of the plaintiffs, finding the TPS termination unlawful. The district judge held that the administration's decision was likely arbitrary and capricious under the Administrative Procedure Act, APA, for example, by disregarding the country's ongoing conditions and instead following a predetermined political agenda to dismantle TPS. Evidence had been presented that the terminations were driven by anti-immigrant animus or predetermined outcomes, rather than careful analysis of conditions on the ground. The suit also alleged a violation of the Fifth Amendment due to alleged racial bias, given statements by officials about Latin American and Nepali immigrants. The district court issued a final order blocking DHS from terminating TPS for those three countries, effectively extending TPS protections for the affected migrants. TPS holders from Honduras, Nicaragua, and Nepal celebrated the decision delivered on New Year's Eve 2025, as it briefly assured them of continued legal status and work authorization. law.ucla.edu. The Ninth Circuit's emergency stay. The government, Trump administration, immediately sought emergency relief from the Ninth Circuit. On February 9, 2026, a Ninth Circuit panel stayed, i.e., put on hold, the district court's ruling. This stay did not contain a full written opinion, it was an unsigned order, but it effectively sided with the government's position temporarily. The panel's short order pointedly cited prior U.S. Supreme Court orders on the interim, shadow, docket dealing with similar issues. In particular, it referenced Supreme Court orders that had allowed the government to implement TPS terminations for Venezuelan nationals pending appeal. "We are not writing on a blank slate," the Ninth Circuit panel wrote, noting that we have been admonished that the Supreme Court stay orders must inform future decisions. This is a remarkable nod to the influence of the Supreme Court's emergency rulings. The Ninth Circuit essentially recognized that the High Court's prior actions signaled how similar disputes should be handled at the interim stage. The Supreme Court's conservative majority has, in recent years, been willing to grant stays allowing government policies, including controversial immigration policies, to proceed pending appeal, even if a lower court found them unlawful. By invoking those precedents, the Ninth Circuit indicated that the same logic applied here, that the government's decision to end TPS should not be halted by a trial judge's ruling while appeals are ongoing. gmla.com, yahoo.com, yahoo.com, yahoo.com. As a result of the stay, TPS protections for Honduran, Nicaraguan, and Nepalese nationals were immediately in jeopardy once more. Their employment authorization documents, EADs, which had been automatically extended by the injunction, could now expire, and DHS announced it would update online guidance to reflect that TPS for those countries is slated to end, urging holders to make preparations. Many of these individuals have lived in the U.S. for 20-plus years, some have U.S. citizen children, mortgages, and businesses. The stay brought deep concern and uncertainty to those communities. One plaintiff, a nursing assistant who came to the U.S. as a toddler, said, "I belong here. I am upset that the court is allowing these blatantly illegal government decisions to go into effect. We will not stop fighting for justice." Advocacy groups like the National TPS Alliance decried the decision for turning their backs on people who have called the U.S. home for decades, including many essential workers hailed as heroes during the COVID-19 pandemic. gmla.com, law.ucla.edu. Legal basis and Supreme Court precedents. The Ninth Circuit's ultimate decision on the merits, and any Supreme Court review, will likely turn on how much deference is owed to the executive branch in making TPS determinations. Under the Immigration and Nationality Act, the executive has broad discretion to designate and terminate TPS. Courts have historically been reluctant to second-guess such decisions unless there is a clear violation of the APA or Constitution. The plaintiffs argue there was an APA violation, failure to consider facts, reliance on prejudice, similar to how the Supreme Court in Department of Homeland Security v. Regents of University of California, 2020, overturned the termination of DACA for being arbitrary. However, the Ninth Circuit's reference to Supreme Court stay orders regarding TPS for Venezuelans suggests that the higher courts may view TPS terminations as within the president's foreign affairs and immigration powers, not readily subject to injunction. Indeed, the Supreme Court in other contexts, e.g., Trump v. Hawaii, 2018, upholding the travel ban, has signaled that courts should not intrude on executive immigration policy decisions, especially those justified on country conditions or national security. It's also noteworthy that the Ninth Circuit's stay was issued by a three-judge panel that apparently did not weigh the usual stay factors in depth, likelihood of success on the merits, irreparable harm, etc., but rather deferred to the Supreme Court's implied guidance. Dissenting voices, such as ACLU attorneys for the TPS holders, criticized the panel for decline to consider the harm their decision would inflict and for overriding a carefully reasoned district court decision without a full review of the merits. They argue this undermines the normal appellate process and demonstrates the outsized influence of the Supreme Court's shadow docket. law.ucla.edu, law.ucla.edu. What's next and implications? The TPS case will continue through the Ninth Circuit, likely an expedited briefing on the merits of the appeal. Meanwhile, unless the Supreme Court intervenes differently, TPS for the three countries could expire. This means tens of thousands of people become undocumented and subject to deportation, although in practice the administration may stagger enforcement. The situation places political pressure on Congress to act. Advocates are urging Congress to create a path to residency for long-term TPS holders or, at minimum, to extend TPS legislatively. So far, such efforts have stalled in a divided Congress. law.ucla.edu. This episode also illustrates how the Supreme Court's conservative shift has real-time effects on immigration policy. Even without a final Supreme Court ruling, the lower courts got the message that the current Supreme Court is likely to favor the executive's authority to revoke humanitarian protections. The invocation of the Venezuelan TPS shadow docket orders demonstrates a new form of precedent. Signals from the Supreme Court's emergency rulings are effectively shaping outcomes before a case is fully decided. This has raised concerns about the shadow docket, decisions made without full briefing or transparency, effectively deciding issues of enormous consequence, in this instance, uprooting communities who have lived in the U.S. for decades. Critics argue it short-circuits the usual deliberative process. Defenders of the court's approach contend that the executive branch must be able to enforce its policies while litigation proceeds, especially on immigration matters where nationwide injunctions can tie the government's hands. In summary, the Ninth Circuit's TPS decision underscores the judiciary's current deference to executive immigration decisions and may foreshadow the eventual outcome. Unless Congress intervenes or the Supreme Court changes course, the termination of TPS for these countries is likely to stand. For the 60,000 affected migrants, many of whom are deeply integrated into American life, this legal battle is literally about the right to remain in the country. As of now, that right is in peril, pending a final resolution of the case. 4. Kerala High Court, corporal punishment ruling in India. The case, in a significant ruling from India, the High Court of Kerala held that minimum or reasonable corporal punishment by a teacher is not automatically a criminal offense, quashing a case against a schoolteacher who had been accused of injuring a student with a cane. The decision, delivered by Justice C. Pradeep Kumar on February 11, 2026, examined the scope of two laws: 1. Section 118(1) of the Bharatiya Nyaya Sanhita, BNS, a provision of the new Indian Penal Code dealing with causing hurt with dangerous weapons, and 2. Section 75 of the Juvenile Justice, Care and Protection of Children, Act, which penalizes cruelty to children. The court concluded that the teacher's act of caning a student's buttocks for discipline did not meet the threshold of a crime under either provision, given the mild nature of the force and the context of discipline. On Manorma.com. Facts of the incident. The case arose from a February 10, 2025 incident at a school in Tiruvananthapuram, the capital of Kerala state. A 36-year-old teacher was accused of striking a student, reportedly a minor boy, with a thin cane on the student's buttocks inside the staff room as a punishment for misbehavior. The student was taken to a local health center complaining of pain, but a medical examination found no visible injury. The doctor's certificate noted no external injuries. Despite the lack of physical injury, police registered a first information report, criminal complaint, on February 13, 2025, leading to charges against the teacher under BNS Section 118(1), voluntarily causing hurt by dangerous weapons or means, and JJX Section 75, cruelty to a child. On Manorma.com. Court's legal reasoning: the High Court carefully analyzed whether the teacher's conduct fell within these penal provisions. On BNS Section 118(1), this section criminalizes causing hurt using a dangerous weapon or means. The court observed that not every object used to inflict discipline can be deemed a dangerous weapon. It depends on the inherent nature of the object and manner of use. A slim cane used for educational discipline, the judge held, is not a dangerous weapon in the context of this law. The statute is meant for knives, guns, or inherently lethal weapons. A cane, in contrast, is a common disciplinary tool that is not designed to cause grave injury. Thus, the charge under Section 118(1) was untenable. On Manorma.com. On JJX Section 75, cruelty to child. This law punishes anyone in charge of a child who assaults, abandons, abuses, or willfully neglects the child in a manner likely to cause unnecessary mental or physical suffering. The High Court emphasized the importance of intent and malice. It cited precedent, including a case called Jomi v. State of Kerala, for the proposition that a schoolteacher has authority to correct a pupil, akin to a parent's authority, so long as the action is taken bona fide for the child's improvement and not to cause harm. The court reasoned that when parents send children to school, they implicitly consent to reasonable disciplinary control by teachers. Therefore, a teacher's corporal punishment must be examined in context. Was it done in good faith to correct the child, or out of anger/ill will to injure? In this case, the evidence showed the teacher administered a light caning with the aim of enforcing discipline, and there was no evidence of any guilty intention to harm or cruelty. The lack of injury supported the view that it was a minimal, corrective action. As such, the court held that continuing a criminal prosecution here would amount to an abuse of legal process. On Manorma.com. Outcome: finding the charges legally unsustainable, Justice Pradeep Kumar quashed the criminal case against the teacher. All proceedings in the trial court were terminated. The court effectively drew a legal line: minimum corporal punishment administered bona fide by a teacher is not per se illegal or criminal. However, implicit in the judgment is that more severe punishment or punishment inflicted with malicious intent would be treated differently. On Manorma.com. This ruling must be understood against the backdrop of Indian law and societal norms. India's Right to Education Act, 2009, bans corporal punishment in schools as a policy matter, and guidelines from education authorities discourage it. However, these are often enforced unevenly. Many schools, especially in some regions, still practice occasional caning or other physical discipline. The Juvenile Justice Act, 2015, was enacted to protect children and had been interpreted by some courts to outlaw all corporal punishment. In fact, in a 2021 case, the Kerala High Court itself had observed that corporal punishment cannot be justified as a measure of discipline, reflecting the growing view that it's outdated and harmful. The present case, however, clarifies that not every incident meets the threshold of criminal cruelty. The Bharatiya Nyaya Sanhita, BNS, referenced as India's new draft penal code, though not yet enacted nationwide as of 2026. Kerala High Court's mention suggests that similar language exists in the current code, or the court was referencing the upcoming legal standard. By saying a cane isn't a dangerous weapon under Section 118, the court signals that normal disciplinary implements are not meant to trigger that criminal provision. Implications and reaction: the judgment has sparked discussion in India about the role of corporal punishment in modern education. Supporters of the ruling argue it recognizes teachers' authority and the reality of classroom discipline, protecting well-meaning teachers from criminal litigation over trivial incidents. They point out that a blanket ban, if interpreted too strictly, could leave teachers hesitant to enforce rules, potentially leading to indiscipline. The court's reference to loco parentis, teachers acting in place of parents, affirms a traditional view of schooling. On the other hand, child rights advocates caution that even minimal corporal punishment can be harmful. They worry the ruling might be misused to excuse more serious abuse. They emphasize that reasonable chastisement standards can be slippery and that the global trend in child rights is moving toward zero tolerance for physical punishment. Indeed, many countries have outlawed corporal punishment in schools entirely. In India, bodies like the National Commission for Protection of Child Rights, NCPCR, have issued guidelines for positive, non-violent disciplinary techniques. Legally, the Kerala High Court's decision is not binding on other states, but it could be persuasive if similar cases arise elsewhere in India. It would not be surprising if police and prosecutors in Kerala become more cautious about charging teachers under child cruelty laws absent clear evidence of abuse. The court even remarked that continuing the prosecution in this case would serve no useful purpose and that it was based on hyper-technical application of the law despite the lack of injury or malice. On Manorama.com. For schools in Kerala, the message is that moderate, well-intentioned discipline, even if physical, won't automatically land teachers in legal peril. However, the boundaries remain. Any punishment causing injury or given with a guilty mind, for example, out of rage or to inflict pain rather than correct behavior, would still be unlawful. The case may prompt school administrations to develop clearer policies to ensure discipline stays within lawful limits, possibly including guidelines on acceptable methods, e.g. light caning on palms or clothed parts of the body, not on the head or face, etc., and training for teachers on alternative discipline methods. Culturally, the issue of corporal punishment in Indian schools is evolving. Kerala, in particular, has a high literacy rate and progressive social policies, yet traditional attitudes towards discipline linger. This verdict straddles that line by neither fully endorsing corporal punishment nor banning it, but by setting a standard of reasonableness and good faith. The conversation it generates may ultimately further the cause of finding non-violent disciplinary alternatives while respecting the need for classroom management. The High Court effectively said, so long as a teacher's action truly aims at the child's welfare and uses mild force, it shouldn't be treated as criminal. It's a nuanced stance that tries to safeguard children from real abuse without criminalizing teachers for using the age-old rod in moderation. 5. Legal implications of the Elk Grove traffic collision, California. What happened? In the early morning of February 11, 2026, a traffic accident occurred at the interchange of State Route 99, North and Elk Grove Boulevard in Elk Grove, California. The crash took place around 6 a.m. on a busy highway during commuter hours. Emergency responders and the California Highway Patrol, CHP, rushed to the scene, which caused temporary lane closures and significant traffic delays. Details were initially sketchy. Reports did not immediately confirm the number of vehicles involved or the extent of injuries. Those facts were still emerging as of that morning. The CHP is conducting an investigation to determine the cause of the collision. Cashlegal.com, Cashlegal.com, Cashlegal.com. Even though the accident itself might not be headline national news, it has legal implications typical of serious traffic collisions. In California, and generally in the U.S., whenever there is a highway accident, several legal considerations come into play: determining liability, who is at fault, handling insurance claims, and potentially pursuing civil lawsuits or even criminal charges, depending on circumstances. Liability and fault. CHP investigators will examine evidence such as skid marks, vehicle damage, eyewitness statements, and possibly surveillance or traffic camera footage to piece together what happened. Common causes of early morning crashes include driver fatigue, low visibility, distracted driving, e.g., cell phone use, speeding, or hazardous road conditions, sometimes fog or wet roads in early hours. If the CHP concludes that a driver violated a traffic law or drove negligently, for example, by speeding or making an unsafe lane change, the driver will typically be found at fault for the accident. In California, a fault state, the at-fault driver and their insurance is legally responsible for the damages resulting from the accident. It's possible multiple drivers share fault. California follows a system of pure comparative negligence. This means each party can be assigned a percentage of fault, and their liability for damages is proportional to their share of fault. For instance, if one driver was speeding and another made an improper turn, each might bear some blame. The CHP report may implicitly or explicitly attribute fault, e.g., by citing one driver for a violation. That report becomes key evidence in later proceedings. Cashlegal.com. Insurance claims: in the aftermath, those involved will file claims with insurance companies. California law requires drivers to carry liability insurance, minimum $15,000 for injury to one person, $30,000 for multiple, and $5,000 for property damage. The at-fault driver's insurance should cover the injuries and property damage of others up to the policy limits. If you were a driver or passenger injured in the crash, you'd typically first seek compensation by filing a claim against the at-fault driver's insurer. If the crash was minor and injuries are minimal, these claims might be handled routinely: medical bills, car repairs, etc., paid by insurance without dispute. However, serious accidents often lead to insurance disputes. Insurers might argue about who was actually at fault, especially if police findings are inconclusive or if drivers give conflicting stories. They may also dispute the extent of damages, for example, questioning medical treatment as excessive or arguing some injuries were pre-existing. If multiple people were hurt and the at-fault driver has minimal coverage, the insurance funds might not fully compensate everyone. In such scenarios, injured parties may need to look to their own underinsured motorist coverage, if they have it, or consider suing for the remainder. Civil litigation: if an injured party believes they are not being adequately compensated, they can file a personal injury lawsuit against the at-fault driver. Common claims would be founded in negligence, alleging that the driver breached the duty to use reasonable care on the road, causing the accident and resulting harm. In a civil case, the plaintiffs can seek damages for medical expenses, lost wages, property damage, like a wrecked vehicle, and pain and suffering. Given that the accident occurred on a state highway intersection, if factors like poor road design or malfunctioning traffic signals contributed, there's a possibility, though speculative, of claims against a government entity, but typically, driver error is the primary cause in such collisions. One detail here is that the accident occurred at a highway interchange. Sometimes these locations have higher risks of collisions, merging traffic, high speeds. If this spot has a history of crashes, it could raise questions about road safety measures. For example, should there be better lighting or signage? However, holding a government liable for road conditions requires proving a dangerous condition and that the agency knew of it, which is a high bar. No information from the accident report suggests a role of road conditions yet. Criminal implications: most traffic accidents are not crimes, they're dealt with through traffic citations in civil law. But there are exceptions. If the CHP finds that a driver was driving under the influence, DUI, of alcohol or drugs, or driving with gross negligence/recklessness, criminal charges can be filed. For instance, causing injury while DUI can lead to misdemeanor or felony charges in California. If, tragically, someone was killed in the crash, a driver at fault could face vehicular manslaughter charges, especially if there was egregious negligence, like intoxication or street racing. At 6 a.m., DUI is less common than late at night, but not impossible, e.g., an early morning drunk driver or someone still intoxicated from the night before. The prompt emergency response and investigation imply the authorities will look into these factors. As of now, we don't have public indication of any arrests, so it may be that this was a negligent accident without criminal behavior. In that case, the legal follow-up will be on the civil side. Process and proceedings going forward: the CHP accident report will be available, individuals involved can request it, as noted in local legal advice websites. This report is crucial for insurance and any court case, as it documents the officer's findings. If you were involved, you'd want that report for your insurance claim. The parties will then either negotiate settlements or proceed to court. Often, injury claims are settled out of court with insurance adjusters. If a lawsuit is filed, it could take many months or years to resolve, possibly going to a jury trial on questions of fault and damages if not settled earlier. CashLegal.com. Implications: while this accident is a local event, it serves as a reminder of how the law handles traffic collisions. Drivers should be aware that insurance is the primary recourse for accident victims, but insurance companies can be adversarial. It's important to gather evidence, photos of the scene, contact info of witnesses, etc., at the scene if possible, to strengthen any claim. The mention of legal proceedings may follow depending on injury claims and insurance disputes is essentially cautioning that if there are serious injuries or contested fault, the incident could escalate to lawsuits. Personal injury attorneys often get involved, as evidenced by local firms like Cash Legal publicizing the incident. Cashlegal.com, cashlegal.com. For the community, an accident on a major route during rush hour highlights road safety concerns. If accidents at that location are frequent, it might prompt local authorities to consider safety improvements, like better signals, ramp meters, signage, etc. It also underscores the need for drivers to exercise caution, especially in known hazard spots. The Cash Legal report noted an uptick in accidents on Elk Grove's major roads, citing distracted driving, speeding, and morning glare or weather as common factors. Cashlegal.com. In summary, the Elk Grove collision will be handled through the standard framework of traffic law and insurance. The outcomes could range from mere insurance payouts to complex litigation or even criminal court, all hinging on the severity of the crash and the nature of any driver misconduct. For those involved, the path to resolution, whether through an insurance settlement or a lawsuit, can be a challenging process, but it is one well trodden in personal injury law. 6. Justice Ketanji Brown Jackson on judicial deliberation and public expectations. U.S. Supreme Court Justice Ketanji Brown Jackson made noteworthy public comments highlighting the court's deliberative process, with specific reference to a pending tariff case. Speaking in a televised interview on CBS on February 10, 2026, Justice Jackson responded to a question about why the Supreme Court had not yet released its decision in a high-profile tariffs case. She explained, "There are lots of nuanced legal issues that the court has to thoroughly consider. The American people expect for us to be thorough and clear in our determinations, and sometimes that takes time." This candid statement, "It takes a while to write," offers a window into the Supreme Court's internal workings and philosophy. Yahoo.com. Context: the tariff case. Although she did not specify the case by name, Justice Jackson was alluding to a pending decision involving tariff policy. Based on other sources, this likely refers to a dispute over the constitutionality of certain tariffs imposed by the administration, possibly tariffs that Congress was attempting to overturn. The U.S. House of Representatives had recently considered a measure related to the president's tariff authority, with Speaker Mike Johnson remarking that it was logical to wait, since the Supreme Court had yet to rule on the tariff case and that the process should be allowed to play out. This suggests the case might involve a question of separation of powers in trade policy or the legality of the president's tariff actions. Regardless, it's clearly a complex case, and the decision was taking longer than some expected. The court's term was about halfway over by February. Yahoo.com. Justice Jackson's comments are significant for a few reasons. Affirming the court's careful process, she emphasizes that Supreme Court decisions, especially on complicated matters, require deep consideration and rigorous debate among the justices. By saying it takes time to be thorough and clear, she reinforces that the court prioritizes getting it right over speed. This counters any notion that the justices might be dithering or unduly delaying. Instead, she frames the delay as a positive sign of diligence. It's an assurance that even though the public, or politicians, may be anxious for a quick outcome, particularly in cases affecting government policy, like tariffs that can impact the economy, the court's responsibility is to deliver a well-reasoned, crystal-clear opinion, which can require weeks or months of drafting and refinement. Indeed, major Supreme Court opinions often go through multiple drafts as justices write majority opinions and dissents, respond to each other's points, and hone their arguments. Public transparency and trust. It is relatively uncommon for a sitting justice to comment on pending cases. Justice Jackson's measured explanation helps demystify the court's operations for the public. This kind of outreach can build public trust by showing that the justices are indeed working thoughtfully behind the scenes. In an era of sometimes rampant speculation, where delays might be interpreted as internal divisions or political maneuvering, her remarks provide a straightforward reason: nuance takes time. Such transparency is part of a broader effort by some justices to bolster the court's legitimacy. In recent years, the Supreme Court has faced public scrutiny and even declining approval ratings. By openly communicating the values of clarity and thoroughness, Jackson addresses the expectation that the court's rulings should be well-grounded. It implies that the court is not indifferent to public expectations, rather, it respects the public enough to ensure its decisions are understandable and carefully reasoned. Comparison with the shadow docket. Although Justice Jackson did not explicitly mention it, her comments draw an implicit contrast with the court's use of emergency orders, the so-called shadow docket. The tariffs case is on the court's regular docket, going through the normal process of briefing, oral argument, and written opinions. Her stress on the painstaking nature of that process, lots of nuanced issues, thorough deliberation, writing clearly, stands in contrast to the far quicker decisions the court sometimes makes on emergency applications, often without detailed explanation. Recently, some justices, and many critics, have expressed concern that the court's increasing use of shadow docket rulings, which often lack transparency and full reasoning, might undermine the perception of careful deliberation. Jackson's remarks can be read as a defense of the regular order of business, where the court's work product is a published opinion that lays out reasoning for the public. It reassures that, at least for merits cases, the justices are taking the time needed to produce quality decisions. Judicial philosophy on clarity. Jackson is also reiterating a point she has made elsewhere about writing opinions in plain language. As the only former public defender on the court and a relatively new justice, she has spoken about making legal reasoning accessible. The comment that the American people expect the court to be clear in its determination speaks to an ideal of transparency and reasoning, that opinions shouldn't be inscrutable to non-lawyers. If the tariff case is highly technical, as many trade cases are, her words suggest the court is striving to explain the outcome in a way that stakeholders and the public can comprehend. This is part of a broader movement within the judiciary to use plain English in opinions and to avoid unnecessary legal jargon. Broader implications. Justice Jackson's interview moment may seem minor, but it reflects the court's awareness of its relationship with the public and the political branches. It comes at a time when there are debates about the Supreme Court's accountability and calls for more openness. For instance, there's perennial talk of allowing cameras in the courtroom, which the court has resisted. While Jackson did not touch on those issues, her willingness to discuss the timing of an ongoing case is a small step toward openness. Moreover, her emphasis on taking the necessary time counters the narrative of those who might pressure the court for faster decisions. In politically charged cases, there is often external pressure, from media, politicians, or public opinion, pushing for an immediate resolution. Her message is that the court operates on its own timetable for the sake of judicial quality. This is an important principle of judicial independence. Courts must not be rushed by public clamor or political timetables. By addressing the tariff case delay, she essentially said, the court is moving at the speed of law, not politics. In conclusion, Justice Jackson's remarks serve to highlight the Supreme Court's deliberate process and to manage public expectations. They indicate that even though a case's outcome may be eagerly awaited, as the tariff case clearly is, given the attention from Congress and the media, the justices will issue their ruling only when they have fully vetted the issues and crafted their opinions with precision. It's a peek behind the curtain that reinforces the idea that justice, especially at the nation's highest court, may be slow, but it is thorough. This can be read as a reassuring sign for those who value rigorous legal reasoning, though it might be frustrating to parties waiting on a decision. Ultimately, Jackson's perspective underscores a long-standing court maxim: justice delayed is not necessarily justice denied, sometimes it's just the product of careful judicial work. 7. Justice Samuel Alito reflects on Antonin Scalia's legacy, from Roe v. Wade to Dobbs v. Jackson. Justice Samuel Alito gave an in-depth interview, published February 10, 2026 in Politico, in which he offered personal reflections on the late Justice Antonin Scalia and drew connections between Scalia's judicial philosophy and the Supreme Court's recent decision to overturn Roe v. Wade. This interview, timed roughly with the 10-year anniversary of Justice Scalia's death, February 2016, provides a unique window into how a sitting justice views the influence of his predecessor on one of the court's most consequential rulings in decades. Scalia's influence on Dobbs. Alito acknowledged that he took inspiration from Scalia when crafting the majority opinion in Dobbs v. Jackson Women's Health Organization, 2022, which ended the constitutional right to abortion established by Roe. Dobbs was the culmination of a legal battle that Scalia had long foreshadowed. Scalia had been one of the most vocal critics of Roe v. Wade, 1973, during his tenure, consistently arguing that the Constitution does not guarantee a right to abortion and that Roe was egregiously wrongly decided. In the 1992 case Planned Parenthood v. Casey, which reaffirmed Roe's core holding, Scalia dissented vehemently, calling for Roe to be overturned. Those dissents, once minority views, laid the doctrinal groundwork for the arguments that ultimately prevailed in Dobbs. Yahoo.com In the interview, Alito said he flattered myself to think that Scalia wouldn't have written it very differently when discussing the Dobbs majority opinion, even suggesting that some of the Dobbs opinion's language may have been influenced by Scalia's style. Indeed, observers noted that parts of Alito's opinion in Dobbs, such as its blunt assertion that Roe was egregiously wrong from the start, echoed Scalia's fiery rhetorical approach. Alito's remarks underscore that the conservative majority's reasoning in Dobbs aligns with the originalist constitutional interpretation that Scalia championed, the idea that the Constitution must be interpreted according to its text and the understanding of those who ratified it, and that it does not silently guarantee rights, like abortion, not explicitly mentioned. Yahoo.com. He started so much, Alito poignantly said of Scalia, "I so often wish he were still here. He started so much and it would have been good to have him around to see it to completion." This statement is loaded with meaning. It suggests that Scalia was a trailblazer for the conservative legal movement on the court, from reinvigorating textualism and originalism to encouraging a rollback of what he saw as judicial overreach and recognizing unwritten rights. Alito's reference to seeing things to completion most clearly applies to the Dobbs decision. Scalia did not live to see Roe overturned. He passed away in 2016, and Dobbs was decided in 2022, but Alito implies that Dobbs was the fulfillment of the project Scalia had championed for decades. Given that Dobbs is likely to be the most significant part of Alito's own legacy, tying it to Scalia's influence is a way of crediting his mentor and solidifying Dobbs in a lineage of judicial thought. Politico.com. Scalia's absence in today's court, Alito also touched on the current climate, noting, "Ever since Nino Scalia died, things are so different." He agreed with an observation that Scalia would have been appalled at the coarsening and polarizing of American politics in recent years. This is telling. While Scalia himself was known for lively and sometimes biting legal prose, his dissents could be scorching. He also famously maintained deep friendships across ideological lines, for example, with Justice Ruth Bader Ginsburg. Alito's comment suggests that the court, and the country, has entered an era of divisiveness that even Scalia, a staunch conservative, would find disturbing. One of Scalia's sons was quoted as saying he was grateful his father did not have to witness the current state of affairs, and Alito echoed that sentiment, indicating Scalia would be unhappy with how politicized and fractured things have become. Politico.com. This part of the conversation highlights an interesting nuance. While Scalia was a hero to legal conservatives and helped pave the way for decisions like Dobbs, he also valued the legitimacy of the court and the civility of discourse. Alito's concern about today's climate may reflect worries about the Supreme Court's perception, for instance, the backlash and protests that followed Dobbs, and the public view that the court is driven by politics. Alito, in defending the decision, perhaps wants to differentiate Scalia's brand of principled jurisprudence from mere political divisiveness. The personal dimension. The interview also gives a humanizing glimpse of Alito's relationship with Scalia. The title of the Politico piece, "He Was the Antidote," refers to Scalia being, in Alito's view, the antidote to stereotypes about Italian Americans and to a certain legal conformity. Scalia was the first Italian American on the Supreme Court, a fact that resonated with Alito, himself Italian American, and many others. Alito recounts meeting Scalia and having a photo of their first handshake hanging in his chambers as a reminder of that friendship and mentorship. This indicates the depth of influence Scalia had on Alito personally. Politico.com. Alito's reflections also implicitly address the notion of judicial legacy. He recognizes that a justice's influence can persist long after they're gone. In many ways, the current 6-3 conservative majority is the fruition of work that Scalia, and allies like Justice Clarence Thomas, spent years advancing when they were often in dissent. By voicing that Scalia started a lot that is now being completed, Alito is acknowledging continuity. The court's dramatic decision to overturn Roe was not a bolt from the blue, but rather the product of arguments honed by Scalia and others over nearly half a century. Implications. Alito's interview can be seen as part of an ongoing effort by several justices to shape the narrative of the Supreme Court's direction. It serves to legitimize the Dobbs decision by rooting it in Scalia's respected legal thought. For those who revere Scalia, hearing that Dobbs might have been written much like Scalia would have done could reinforce the decision's intellectual credibility. For critics, it may underscore their concern that the court's majority is pursuing an ideological agenda set by conservative icons of the past. Additionally, Alito's comments on the political climate feed into the conversation about the Supreme Court's role amid partisanship. He seems to lament that confirmations, like his own, which was contentious, 52-48, have become battles, a far cry from Scalia's unanimous confirmation in 1986. This again touches on how things have changed in a way Scalia might not have liked, despite Scalia being a polarizing figure in decisions. The process and perhaps the public's trust in institutions have deteriorated further since his time. Politico.com. In summary, Justice Alito's reflections cast Dobbs as a fulfillment of Justice Scalia's constitutional vision, while also sounding a note of concern about the current hyperpolarized environment. It highlights the enduring impact a single justice can have. Scalia's interpretive philosophies, originalism and textualism, now guide the court's majority, affecting rulings on abortion, gun rights, religious freedom, and more. For legal scholars and court watchers, the interview is a vivid confirmation that the ideological trajectory from Roe, 1973, to Dobbs, 2022, was strongly influenced by Scalia's legacy. As the Supreme Court continues to tackle divisive issues, the camaraderie and intellectual lineage between justices like Scalia and Alito also remind us that the court's dynamics and decisions are shaped over decades, not just by present circumstances but by the persistent influence of ideas and relationships that transcend individual lifetimes. Yahoo.com. Sources.